Stephen A. Williams, president and founder of the creditrepairshop.com. In today's video, we're going to take a deep dive into the 2017 court case Henson versus Santander USA Incorporated. This decision clarifies a key aspect of the Fair Debt Collectors Practices Act, or the FDCPA, and has major implications for debt collectors and consumers. So let's get started. So what was this case about? In short, the issue was whether a company that buys debt for its own collection qualifies as a debt collector. Under the FDCPA, the Fair Debt Collectors Practices Act, in this case, Santander Consumer USA had purchased auto loan debt and sought to collect directly from borrowers. So let me kind of clarify. Santander USA, which is a auto lending institution, was also buying auto debt debt that was repoed. So companies who had repoed the debt, repoed the cars, they had that deficiency balance. They were buying those deficiency balances and going after consumers. So the key legal question was, does the Fair Debt Collection Practices Act apply to companies like Santander, which collected debts they own? They were buying the debts and then they were collecting on those debts, even though those debts were charged off debts from other companies. The Fair Debt Collectors Practices Act defines a debt collector as someone who collects debts owed or due another. So was Santander a debt collector or just a creditor collecting its own debt? So now, think about this. Even though Santander did not make the loans, even though Santander was buying those debts for pennies on the dollar, and then going out there actively like a debt collector, were they considered a debt collector under the Fair Debt Collectors Practices Act? So, in an 8-0 decision written by Justice Gorsuch, the Supreme Court ruled that Santander is not a debt collector under the Fair Debt Collection Practices Act. Why? Why did they state that? Because it wasn't collecting debt owed or due another. So it wasn't collecting on debt that was owned by another company. Now stay with me, because this is this is a loophole. This is a loophole for debt collection companies. So now, this decision has significant implications. So, limited scope of the Fair Debt Collection Practices Act. The ruling narrowed who the Fair Debt Collection Practices Act applies to. Companies collecting debts they own are treated differently from third-party debt collectors. Even if they're buying charged-off debt, and they buy that debt for pennies on the dollar, and they go out there and they try to collect on that debt, they are not technically under the Fair Debt Collection Practices Act. This is why a lot of people, when they're disputing debts that they receive from a debt collection company like Santander that they know that they didn't have a loan or anything with, and they're like, why isn't this company responding in the way that you would think that they should respond according to the Fair Debt Collection Practices Act? This could be the reason why. So, consumer protections. Borrowers lose some FDCPA protections. Which protections are they losing? Well, when dealing with debt collection companies like Santander, including limits on harassment and abusive practices. So, they can't go crazy and, just violate your rights. There are standards. But when it comes to the amount of times that they can call you, when it comes to the amount of times that they can do certain things that the Fair Debt Collection Practices Act considers harassment, may not be considered harassment. And let me clarify one specifically. And we run into this a lot. When consumers, like you hear this a lot, complaint a lot with people who sign up with debt settlement companies. During that 180-day window until they charge off your debts, they can blow your phone up saying, why aren't you paying? You need to pay us, this and that. You know, they could do everything and anything to get in contact with you because that debt is not charged off. And even when it charges off, until they determine on what they're going to do with it, the process still can remain the same as long as they don't sell it. But there's usually that period of time before they, in a way, technically give up on it and do the charge off, where they will just blow your phone up. They're going to call you every day. They're going to call you at time, like 8 o'clock at night. They're going to try to figure out ways to get you on the phone. They can do that because they're the original creditor and they're not under the Fair Debt Collection Practices Act. So you might be like, they're harassing the hell out of me. They're blowing up my phone. They have a right to do it. And you can't even really send them a cease and desist because they're not a collector. They own the debt. They're like, you owe them the money. And so if a debt collector buys debt and they're not collecting debt for other companies, they can technically do that same thing to you. They can blow your phone up and they can say, hey, we're trying to collect on this debt, and they purchase that debt. They're going to identify that they purchased the debt, but the thing is that they know that certain protections that you had under the Fair Debt Collection Practices Act, the FDCPA, will not apply because they are considered from the Supreme Court as the creditor. So now, here's another thing to think about, which is what's considered like a corporate strategy that some of these companies are looking at doing. Debt collection companies is some companies might now purchase debt outright to avoid being labeled as a debt collector under the Fair Debt Collection Practices Act. This is something that we've been seeing prevalent, and the way that they used to do it is they would have a company purchase a debt, which would usually be called a portfolio company, and then they would pass that along to their LLC debt collection companies, and they did that to give protection to the main what would we call it, the main company. They wanted to protect the main company. So if one of their offshoot LLCs does something wrong, they could just pay the fine, shut it down, put another one. That's why you'll see companies like LLC 1, LLC 2, or holding company, like the same name, but they just added another letter or digit or another name to it, or holding company to it. This is the way that they were doing it. But now with this decision, what they've been doing is like, we can form a company, buy the debt under that company, and collect the debt under that company as the original creditor. Okay, so now critics of the decision argue that it weakens consumer protections by creating loopholes. They fear that it would encourage aggressive tactics by companies collecting debt they own. However, supporters say it aligns with the text of the Fair Debt Collection Practices Act and prevents overregulation. So what does it mean for you? If you're dealing with a company like Santander that owns a debt, the Fair Debt Collection Practices Act may not apply. However, state laws and other federal protections could still offer safeguards, and always review your rights. Consult with an attorney if you could do that, or we're always willing to review your documents also here at the Credit Repair Shop. So to wrap everything up, and this is what will still work regardless of the situation, is that debt collection companies, even if they buy debt and they own the debt, they have to prove, so if you look at it this way, let's look at this logically. Debt collection company like Santander buys a debt. When they buy a debt and they're assuming as the creditor, if you are the creditor, let's just say that a company is the creditor, you're with the same company and there's a dispute with the debt, with the amount, whatever there is. How would you approach that company to prove the amount that they're claiming that you would owe? That same way that you would approach that company for them proving what they claim you owe is the same way that you would approach a company like Santander who is buying your debt. You might be saying, well, Steve, what is the way that you approach them? You make them prove everything, all of the documents. If you assume the position of the creditor, that means that I want everything that the creditor would have had. It needs to be passed on to you. If anything was not passed on to you appropriately, that means that you're in violation of just buying those portfolios. You're in violation of not having all the documentation to even prove a debt that you're claiming that someone owes. So they have their loophole. You still have you still have the same process. It's just that you need to, when you're going through that process, you're going to have the understanding that there's some things that they're going to be able to bypass because as the creditor, they're not going to have to follow by the letter the Fair Debt Collections Practices Act rules. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch video What Makes Us Different so you can see my 8-point validation process, my 2-phase settlement process. We're coming up on a new year. You need to make your credit a priority. We live in a credit society, and if your credit is a priority, a lot of things will not be able to happen to you. A lot of stuff like this is a result. This is the result of things that are affecting you on your credit. If you need your credit reports and scores, because you should always know what's on your credit reports, because if you know what's on there, you know what you have to tackle to be able to get to the next level. Go to the website yourthenumber3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you, grab my 3-pack of letters: statute of limitations letter, debt validation, and cease and desist collection activities letter. Those letters can save you time, money, and frustration. I do ask for a donation on those, and I appreciate everyone who does donate to them. I really appreciate that. But you don't have to get it. Go to the website. All the links are below this video. Thank you for your time. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.